Welcome back to Freedom, Facts, and Firearms. My name is Novak, and today we'll be getting into the history of concealed carry. As we've learned in prior episodes, arms laws varied throughout the centuries. It was in the 1300s where the carrying of arms was brought into the spotlight and stricter laws started to appear. The most known and cited law is the Statute of Northampton. Keep this statute in mind, as it is one of the three major legal arguments used in the U.S. today. The Statute of Northampton was enacted in 1328 under Edward III. The statute sought to restrict the carry of arms, and it read, Item, it is enacted that no man great nor small, of what condition soever he be, except the king's servants in his presence, and his ministers in executing of the king's precepts, or of their office, and such as be in their company assisting them, and also, upon a cry made for arms to keep the peace, and the same in such places where such acts happen, be so hardy to come before the king's justices, or other of the king's ministers doing their office, with force and arms, nor bring no force in affray of the peace, nor to go nor ride armed by night nor by day, in fairs, markets, nor in the presence of the justices or other ministers, nor impart elsewhere upon pain to forfeit their armor to the king, and their bodies to prison at the king's pleasure. And that the king's justices in their presence, sheriffs and other ministers in their bailiwicks, lords of the franchises and their bailiffs in the same, and mayors and bailiffs of cities and boroughs within the same cities and boroughs, and borough holders, constables and wardens of the peace within their wards, shall have power to execute this act, and that the justices assigned at their coming down into the country shall have power to inquire how such officers and lords have exercised their offices in this case, and to punish them whom they find that have not done that which pertained to their office. So basically, this statute only allowed for the king's servants and ministers to carry arms, and limited where arms could be carried, and set forth the confiscation and imprisonment of those who violated the order. It was an attempt to make most locations sensitive places and eliminate the carry of arms. Sounds a lot like what some states are trying to do today. However, it was later made clear that an indictment for the violation of the Statute of Northampton must specify that the arms carrying was in curandum de populo terror, or to the terror of the people. So whilst the king sought to disarm the populace and restrict where arms could be carried, the courts and common law rulings dictated that a charge could only be made if one was terrorizing the populace, either by carrying arms or through their conduct with the arms. Following the Statute of Northampton, Edward III declared further restrictions by amending the Statute of Northampton in 1350, and it read, And if per case any man of this realm ride armed, or secretly, with men of arms against any other, to slay him, or rob him, or take him, or retain him till he hath made fine or ransom for to have his deliverance, it shall be judged felony or trespass, according to the laws of the land of old times used. So this amendment came into effect because at the time concealed carry was popular, and it was an issue because many criminals would conceal their weapons and go on offensive attacks. This amendment made concealed carry a crime if it is being done in an offensive manner. This particular order would come into play in the United States in 2021 in the Young v. State of Hawaii case. This case was regarding concealed carry in Hawaii. The Ninth Circuit, the most corrupt and overruled court in the United States, sought to promote and push gun control to such a degree that they would take a directive made by the King of England in 1350, alter it, and use it as a valid legal argument. They would declare that the Second Amendment right to bear arms does not apply to carrying arms outside one's property or in a concealed manner. The court quoted the aforementioned 1350 law, but omitted the text, slay him, rob him, and take him or retain him. Thus a law that was properly targeting felonious behavior with arms was turned into a widespread general all-encompassing ban on the carry of arms anywhere outside the home. I want you to think about that. Think about how an English law dating prior to the discovery of North America and having no weight or relevance in U.S. law or history and was outright rejected by the Founding Fathers could be used in a modern day U.S. federal court to enact gun control. It's asinine. The Ninth Circuit has no credibility and deserves no honor or respect or to have any of their rulings followed. In later centuries, more restrictions on carry would take effect. In 1541, King Henry VIII forbade riding on a highway with a loaded gun or crossbow, but made exemptions for those that met the minimum income requirements for owning those arms. In 1613, King James I banned concealed carry, proclaiming, "The bearing of weapons covertly, and specially of short dags, and pistol, had ever been straitly forbidden." His complaint was that the practice had become very common. It wasn't until 1615 that the first reported case of the Statute of Northampton was used, in Chun v. Piat. The ruling by the court read, "Without all question, the sheriff hath power to commit excustos and conservator passis, if contrary to the Statute of Northampton, he sees any one to carry weapon in the highway, in terram populi regis, he ought to take him and arrest him, notwithstanding he doth not break the peace in his presence." This gave a sheriff the power to arrest someone upon suspicion of breaking the peace without being an actual witness to it or the incident happening within their presence. Once again, in 2021, in the Young v. Hawaii case, the Ninth Circuit used a ruling from a different country, omitted wording resulting in changing the meaning, and applied it to U.S. law. The Ninth Circuit omitted the last three words, "in his presence," which changed the meaning from the sheriff can arrest when they did not witness the breach of peace to sheriffs can arrest even when there is no breach of peace. Just another example of the corruption and worthlessness of the Ninth Circuit and why no case should ever be heard by them and no ruling they make ever hold water. This ruling literally meant that a sheriff would go from being able to arrest someone on suspicion of committing a crime to being able to arrest someone for absolutely no reason at all. In 1618, instructions for arrest were further clarified. It stated that those that ride armed in an offensive manner or shall wear or carry dags or charged pistols, even for defense, could be arrested because it strikes fear and terror into the knight's subjects. In 1622, this was further revised, and the part of defensive carry was removed under the condition that the arms were concealed, for there is nothing openly done in terror of the populace. In 1685, a case took place called Rex v. Sir John Knight. Knight had been arrested for violating the Statute of Northampton by carrying arms in the streets and into church during services, purportedly in terror of the populace. Knight was acquitted by a jury. His attorney pointed out that the statute was made to prevent the people's oppression, but since this was a private matter, the statute did not apply. The Chief Justice did state that to go armed to terrify the king's subjects was a great offense at the common law, but also acknowledged that this state be almost gone and destitutum, for now there be a general connivance to gentlemen to ride armed for their security. The court's ruling held that the statute had fallen out of practice and was rarely, if ever, enforced. It also acknowledged that men willfully and commonly ride armed for their security. Once again, this English case existing prior to the establishment of the United States is cited and used in U.S. courts and in cases involving gun control. Some of those cases being the New York State Rifle and Pistol Association versus the City of New York and Puerta v. County of San Diego. What relevance English law and cases have in modern U.S. law is lost on me, as the founders outright rejected the English Bill of Rights as being too weak, their laws too oppressive, and arms control unacceptable. We will get into more examples and details of that as we move closer to the U.S. colonial period and the Revolution. It was further clarified in 1707 in Queen v. Solely that though a man may ride with arms, yet he cannot take two with him to defend himself, and even though his life is threatened, for he is in the protection of the law, which is sufficient for his defense. This is an interesting one, because all the people that want to apply Old English rulings to modern U.S. law seem to choose the ones about gun regulation and disarmament, but ignore ones like this, which point out individuals may carry arms, just not in groups made for the protection of someone or as a gang. It would later be explained by William Hawkins in a treatise on the pleas of the crown what the common law offense of affray was and the influence the Statute of Northampton had. An affray was a public offense to the terror of the people. Words could not be considered an affray. Section 4. But granting that no bare word in the judgment of law carry in them so much terror as to amount to an affray, yet it seems certain that in some cases there may be an affray where there is no actual violence, and where a man arms himself with dangerous and unusual weapons in such a manner as will naturally cause a terror to the people, which is said to have always been an offense at common law, and is strictly prohibited by many statutes. Section 9. That persons armed with privy coats of mail to the intent to defend themselves against their adversaries are not within the meaning of this statute, because they do nothing in terram populi. The summary of this meant that carrying dangerous and unusual weapons in public was illegal because it was inherently terrifying, even if done for self-defense, but carrying common weapons was only an offense when apt to terrify. Concealed carry of armor was not an offense, as it could not bring terror to the populace because it was not visible. So walking down the street with a flamethrower would be illegal because it is inherently terrifying. But if you have something on you that is concealed, it isn't, because nobody knows it's there. In 2008, the U.S. Supreme Court would change the meanings of these interpretations to fit a political purpose in District of Columbia v. Heller. The court turned the provision that the public carry of dangerous and unusual weapons isn't allowed into a law stating the ownership of such arms can be completely prohibited. Yet again, an English law from before the founding of the United States, outright rejected by the founders, was used for arms control in modern America. It is beyond my comprehension how any court can take case law or laws from another country and hold them to have any validity or weight in our own. In 1820, case law from Rex v. Dewhurst held that a man has a clear right to protect himself when he is going singly or in a small party upon the road where he is traveling or going for the ordinary purposes of business. But I have no difficulty in saying you have no right to carry arms to a public meeting, if the number of arms which are so carried are calculated to produce terror and alarm. In 2001, the UK's highest court held that the carrying of dangerous weapons, such as petrol bombs, by a group of persons can constitute a threat of violence. Mere possession of a weapon without threatening circumstances is not enough to constitute a threat of unlawful violence. So, for example, the mere carrying of a concealed weapon could not itself be such a threat. So even the modern UK courts have rejected that the possession of a dangerous and unusual weapon is not in itself a crime. It is only a crime when done in threatening circumstances. The Statute of Northampton and its common law foundations have been consistently interpreted by UK courts from the first reported case in 1615 to current day as meaning the peaceable carry of ordinary arms is lawful. And that's where we're going to end today. I hope you guys are starting to see the impact English law and history has had in modern American firearms law today. Be sure to tune in next week as we will be getting into colonial American law and how Americans applied and used English law. Thanks for watching.